news on the channel at this hour. The man accused of the Diepsloot Child Murders has been found guilty at the High Court, the North Gauteng High Court in Pretoria. Ntokozo Hadebe has been convicted of 3 counts of murder, 3 of kidnapping and 6 of rape. The bodies of Annalisa Mkondo and cousins Yonalisa and Zandile Mali were discovered dumped in a rubbish bin in public toilets last year. They'd been abducted, taken to Hadebe's shack in Diepsloot, where he'd raped and killed them. Just a short while ago, Hadebe was on the stand giving evidence in mitigation of sentence. Let's go to that High Court, where our reporter Sibongile Mkani-Mpolweni is standing by for us with the latest. Good morning to you, Sibongile. What was the reasoning behind the judge's verdict?
Good morning, Joanne. The judge found Hadebe guilty on all counts. Firstly, because of the confession he made shortly after he was arrested on the 18th of October last year. He made a confession to a magistrate where he was read his rights and he confessed to killing all the girls and raping them. Secondly, the judge also said that the evidence, DNA evidence of blood in his check of the 3 little kids in his suitcase also linked him, and also DNA true specimens that were taken from him and the kids, that the bodies of the children. So he was saying that evidence against him was overwhelming, and the fact that there were 2 witnesses on that day at the spaza shop that testified that they saw him with the little 2 girls, and that the other lady spoke to him and said, "Why are you buying yourself beers and not buying the kids sweets?" And he then bought the kids sweets, and he even admitted to that lady that he was with the kids, but the mom was following behind. So that was the overwhelming fact that the judge found him guilty.
How did Hadebe react to the ruling?
Throughout the trial, he's been sitting there looking at the roof, showing no emotion or any sort. Even today, when he took the stand after mitigation, when he was asked if he wanted to sit down, he said no, he will stand. And he just said that when his lawyer asked him if he wanted to say anything to the victims' parents, he said no, he's already been found guilty, so it won't change anything, whatever he says. And then he later said that he's mentally ill, he's crazy, and that he's been crazy since 2002. And when his lawyer said, "Why didn't you inform the court? Because throughout the trial you never said anything," and then he said, "Well, I thought the court would see and recognize that I'm not a mentally well person."
And it's interesting, he's shown no remorse whatsoever throughout this trial, and just reading a quotation from something he said earlier, he says, "It's just my bad luck that witnesses are incriminating me in 3 murders I did not commit."
Yes, he's shown no remorse at all. Even now, they are asking him, "Is there anything you want to say to the families?" He's saying, "No, the court has found me guilty anyway, so there's nothing I should say to them." And even when he was told of the DNA evidence, he just said that these scientists will get innocent people into jail, and he's denied involvement. He's even denied that he spoke to that lady at the spaza shop and that he was with the kids on that day.
Sibongile, what some viewers may find interesting is that sentencing procedures have begun already. I mean, we saw in the Oscar Pistorius trial the length of time between the judge's actual ruling and when sentencing procedures began. Is this par for the course, that the court should move ahead so quickly?
Yes, it is part of the court, especially when a case is this, I would say, straightforward as this one, because there was lots of evidence pointing to the accused, his confession that he made himself to the judge, which was submitted as evidence, made the judge's job, I would say, easy, because everything was there. He confessed to the magistrate, the DNA linked him, there were witnesses who saw him with the kids, the blood was found and clothes of these kids were found in his check, so everything pointed to the suspect.
It just gives us a sense of what sentence the state is asking for.
Right now, when I was about to talk to you, the state was about to in fact, it was the defense who was stating the special circumstances of the accused. So they haven't gotten to that yet. When we go back to court now, they will start with that.
It's interesting that he's introduced this at this stage, claiming to be mentally unfit. He would have gone through the process of psychological evaluation before this case got underway, would he not have?
Under normal circumstances, people are taken true. I remember there was something last year where they were saying that they would take him for evaluation because he was even taken to a doctor. Because now another thing he claimed through this trial was that he was beaten up by police and was forced into making that confession. But he told the magistrate that when he was making the confession that he was making it out of his own free will and that he had not been assaulted. But the magistrate, after taking the confession, took him to a doctor who examined him and found no visible injuries or fresh wounds that would suggest that he had been assaulted. But now he claims he doesn't remember all of that and what had happened throughout the trial.
So there's no chance at this juncture that evidence could be introduced in mitigation of sentence regarding his mental state or his mental fitness to stand trial?
We will hear that when court resumes, Joanne. I don't want to speculate. I don't know what his defense will say.
Thanks very much for putting us in the picture. Sibongile Mkani-Mpolweni, live to us from the North Gauteng High Court.